Hello, everyone. My name is Nick Hajdukovic. I am the chair of the Mock Trial Committee. I want to welcome everyone to today's webinar. We have two main topics for the team training this year. The first will be a rules update from Randy Sparling, and the second will be a case presentation by myself and Peter Stelter. If you have questions as we go, please use the Q&A function. It should be at the bottom of your screen. We'll monitor that and answer questions the best we can as we go. So with that, I'll turn it over to Randy for his rules presentation. Randy?
Thanks, Nick. We really don't have a lot in terms of updates to the rules. So really what this is primarily going to be is an attempt on my part to share with you what I think everybody should be thinking about in terms of the rules and how they apply.
Randy, I would just go ahead and start on rule 3, and we will post this PowerPoint online if people
Thank
would
you.
like to refer back to it.
All right. So there is an update, a minor update we have this year in terms of the rules with respect to the something that's been always in our practice, and that's the members on the advisory committee are who are involved with coaching a team are not allowed to have any access to the case. And there's certain aspects of the program which are confidential, which we're supposed to respect the confidentiality, and that's one of them. Additionally, it's not appropriate for participants to seek to access confidential information through anybody who is involved with the advisory committee. The rules of competition are divided into sections, and the first section is A for administration, and I'm just picking out a couple of things that are there. One rule is 1.5, and that's accommodation. So if anybody on your team has a need for some accommodation due to physical challenges, then you need to be in touch with the mock trial director to make arrangements so that you've got that accommodation that can be made. So just you contact him and she'll arrange for that. The the Kim, are you? Is this your version or mine? Okay. Gosh, I'm sorry. I really apologize for this. Section B in the rules is the problem, otherwise known as the case, and that actually makes up a good chunk of the rules. But there's just a few things that you need to be aware of. That sure, you'll look at the case materials, but there are some needs to be aware of some of the rule requirements. One of them is in 2.2, which are that rules that the witnesses are bound by their material, and the rule of unfair extrapolation. The rule prohibits unfair extrapolation. So it's something you need to be familiar as a witness so you know what you can testify to, and you need to be aware of it as an attorney so that you can make an objection. You can actually make an objection under Rule 2.2. If that occurs, the presiding judge will allow, like any kind of objection, for there to be some kind of argument. Is this a fair extrapolation or unfair extrapolation? So it's something to be aware of out there. 2.3 is similar, and it binds the witnesses to what they know about in connection with the case. And we've accommodated that in the last few years by having at the end of every witness statement an indication of which exhibits that the witnesses are familiar with. So it's not just your statement, it's also what's stated in the exhibits that you have knowledge of. The next section, subsection C, deals with the teams. Teams consist of 6 to 8 members, 3 attorneys, 3 witnesses, and the other 2 could be somebody acting as the bailiff or as the timekeeper. 3.4 deals with team duties, and it's one of those things that everybody should be aware of. And sometimes you think it's that situation, but I had one round some years back where one attorney did all the direct examinations, and I'm sitting in the back room going, "You can't do that." So It just a rule to know that every attorney is going to do a direct examination and a cross-examination. And in your cross-examination, you're the only one who can respond, make an objection, or correspondingly, the directing attorney has to respond to that. It can't be somebody else on their team. Um, the trial, subsection D, the courtroom setting, the plaintiff this year, it's a civil case that's closest to the jury. You need to use proper decorum in the court. And the presiding judge is going to run the show. They're going to allow counsel to argue matters, and then they're going to and then deal with standard evidentiary issues. Rule 4.2, this is stipulations, and I see a lot of folks tend to not pay sufficient, in my mind, attention to the stipulations. Most of the stipulations this year, the first 10 deal with evidentiary matters, exhibits, and how it is that they're allowed to be coming in. And the last two deal with some pretty substantive and important matters that are relevant to this case. So don't skip over those. You need to be aware of them. That said, they're deemed to have already been admitted, so you don't have to read them into the record or anything like that. Rule 4.5 deals with time limits, as you probably all know, 5 minutes for the opening statement, and then we get into shared time. Shared time for direct is a total of 25 minutes. Shared time for cross-examination is 18. Then at the conclusion of the last witness from the defense, then there's to be a break for a couple minutes for folks to prepare for their closings. Plaintiff goes first, and they have up to 3 minutes. You don't have to reserve a specific amount. You are able to just spend any additional unused time for purposes of doing your rebuttal, which has to be responsive to what the defense did in their closing. Rule 4.6, if you're the timekeeper, this is where you need to be really aware of. And fortunately, we also have timekeeper training, which there's going to be a recording of. So I highly recommend anybody who's going to be a timekeeper view that stuff so that they have awareness of what they're supposed to do. I also highly recommend that you go get countdown timers. So you set one, for example, for your 5 minutes of direct examination and the 18 minutes for the other team's cross-examination. Then you don't have to do the math figuring out, okay, well, we have a 7.5 minute and then we have a 13 minute, and it's much easier. So just think about how you're going to be doing that rather than using a stopwatch. Continuing on the trial communication, 4.12, there's not supposed to be any communication by the spectators, the coaches. They're all supposed to be behind the bar, and allow the teams to go forward. Witnesses really aren't supposed to be talking with each other. It's the attorneys that can consult, but you need to be careful about that, not to make it a distraction. 4.15 says we're in a jury trial, and that means you get to use your opening statement, closing arguments to the jury, which would be the scoring judge or judges, as the case may be. I highly recommend that in the courtrooms where you have a jury box, that you allow the scoring judges to sit in the back row closest to the bench, so that they're able to. It's easy for the lawyers and the witnesses to make eye contact with them. Minnesota, in our mock trial, the attorneys are supposed to stand if they're able to. And if they're not able to, then they need to get excused from the judge. In standing in their statements and the questioning in the closing arguments and in the objection matters. 4.20 is very helpful. It's a step-by-step guide as to how you get an exhibit in. One thing that's a little bit unusual is this is our competition. So 4.23.1 deals with the team conference. After the closing arguments are complete, only the attorneys, the witnesses, the timekeeper, and the bailiff, all of you can get together and huddle, and you've got a couple minutes to do two important things. One is to decide if you want to assert that there's a serious rule violation, and more importantly, to pick who you want to designate as the outstanding performing attorney and outstanding performing witness on the other team. My suggestion, my team has always been let the witnesses decide who the best witnesses are and let the attorneys decide who the best attorneys are. And then you can be getting both of those done a lot simultaneously and speed that along. Keep in mind, if you're going to make an objection of a violation of the rules, be careful about that because it is possible that the scoring panel can assess you a penalty point for asserting what amounts to a frivolous claim. Part E, judging and team advancement. Although this isn't something that you necessarily are going to need to be dealing with, it's just to note that the way that we work this is we hope that we have three judges available. One would be the presiding judge, and the other two would be the scoring judge. Even then, though, the presiding judge will keep a score just in case there's an issue or a problem, or potentially to break a tie. And then we have a very long set of rules with respect to the competition format. The things that you will want to know is that each team you're assigned to a region, and you've got 4 rounds. The first 2 rounds, you'll be on one side of the case one week and the other side of the case the next week. And those are all set and matched ahead of time. After that, we look at, we establish 3 pools. We've got teams that are 0-2, and they're going to have rounds 3 and 4 against each other. And then we have teams that are 2-0, and we have teams that are 1-1. The third round, it's going to involve the 1-1 teams facing 2-0 teams, and then the final round, it's 1-1 teams facing other 1-1s and 2-0 teams facing 2-0. So theoretically, the competition should be getting a little bit tighter as the season goes on. The regional championship is done on a power matching basis, where based upon the record of the teams. The first factor is win-loss, then it gets to be a point differential, and then finally cumulative points. We then in subpart G, we have courtroom artist contest. We do have some update this year, and that relates to the process for making the submissions. The submission is to be with respect to the second round, the live round. We're not going to be looking for submissions coming out of the virtual rounds 3 and 4. If, however, the artist is either an attorney or a witness that's competing in the second round, but not on the side of the case that's going in the first round, they're able to submit their drawing. And the drawing is supposed to be submitted to the presiding judge, and then that will be making its way to determine which are the top 8 artists to compete at the state tournament. Second area of rules we've got are the rules of evidence, and they're based upon the federal rules, which also Minnesota's rules of evidence are based upon. So if you ever want to do some research, you can do that online and find a whole lot of information, and that helps you perhaps better understand stuff. The fourth article deals with relevance. And basically, one of the things that we have is we have a relatively low bar. In other words, it's unlikely that you're going to exclude irrelevant information. But we do have the potential that relevant information could be excluded if it's unfairly prejudicial. It's that probative value weighing against the prejudicial nature. If it's going to be misleading, so that you might face objections on those things, or you might make objections on those things. So as you go through the witness statements, take a look and try to understand where you might run into some issues. Article 6 deals with witnesses, and the 2 things I pull out are the character and conduct of the witnesses. Or specifically, you're not supposed to have a past action or conduct establish that somebody did something this time. So there are a few exceptions out there. Mostly they come along in some of the criminal cases, but this year's the civil case. But that can sometimes be a problematic issue. But not sure from my brief reading of the case so far, I'm seeing a lot there in that one. Um, Article 7 deals with opinions and experts. 701 deals with non-expert, otherwise known as a lay witness. Non-experts can give an opinion as long as it's helpful for the jury to understand their testimony or determine an important fact in the case. Requirement is that the opinion that the lay witness is going to give you has to be rationally based upon their perceptions. So if you think about that, that means you can't have a hypothetical situation. So even if it's a lay witness who's going to express an opinion on something that may be helpful for the jury, it's not something that is based upon what something they saw, smelled, felt, saw, whatever. So it's got to be, so you can't ask a hypothetical question. Rule 702 is for experts. You qualify the experts, and so that if you're going to be doing the directing or the crossing, you'll want to pay a little bit of attention about that, what the expert witness may or may not be able to do. Lastly, hearsay, Article 8. Um, and I always say that so much of law can be in the definitions, and that's particularly true with respect to hearsay. And there's some odd terminology here. The first thing that's defined is a statement. That can be something that's spoken. It can be something that's nonverbal. It can be written communication. And this year we have a video, and that's a video that's an out of court statement, and that's would constitute potential hearsay. You have somebody then you have this weird term, a declarant, declaration. The declarant means that's the person who's making the statement. Hearsay is defined to be other than when the declarant is testifying in court where something that the statement was made is being offered to prove the matter asserted in the statement. So sometimes the fact that somebody said something on its own has evidentiary value, not necessarily that what the statement says. Classic would be, I looked up there and I saw the light was red, and somebody heard that, and so they are going to testify. Well, this person said they looked up and said that the light was red. Well, uh, it may be that would be hearsay if you're trying to offer it for the purposes of establishing what the color of the light was, but it could be for other purposes, and thus allowed to come in. And then we have the odd thing in definitions where they're declaring some things just to be not hearsay. Um, the one that we most commonly run across is the second one, admission by a party opponent. So if the plaintiff said something and one of the defense witnesses is coming in to offer that, the party opponent is the plaintiff. A party opponent is not a witness from the other side of the case. It's only in this case the plaintiff and the defendant are the only potential people that could be party opponents that a statement that they make comes in. Then you have prior statements of the declarant, but that requires that the declarant be on the stand testifying. And so if you have them, for example, their witness statement says one thing, and on the stand they're saying something else, if you're going to cross-examine them, you don't necessarily, so you're going to come in and you're going to use that out of court statement to show that that their testimony today is inconsistent with the statement that they made previously. Conversely, it could be used by if the other side is making that argument, there's an inconsistent statement. If the directing attorney can pull out the prior statement, show no, this is what they put in their witness statement, and that is a consistent statement. The one where we're probably not going to get seen too much is when there was a previous identification. The classic in a criminal trial, you have the defendant who is identified. Yes, he's sitting there in the blue shirt over there next to the attorney. But you might have a situation where the witness in the classic criminal movie goes to the lineup and says, yeah, it's the second guy in from the left. That's the one who stole my car. And so that out of court statement to the officers of identification is something that then could be brought in. But it's still going to require that the declarant be present and testifying. So I scratched my head a little bit thinking about, well, what does that mean? It's that they just identified the defendant. Why would you need to have this other statement? Well, it could be it falls can maybe into that category of this is consistent that they recognized him before and they recognized him in the lineup. But again, that's in a criminal case, which we don't have. Um, the rules for the artist competition are a little bit updated this year. They're to give the statements. Oops, that's out of order. And I guess that will wrap it up. If you've got any questions, please, I'll seek to address them. Only other thing I'll say is we do have those rules with respect to the virtual competition, and those are done either as general rules or they're specific modifications of rules to be aware of. But that's something that we have to deal with halfway through the season. Thank you.
Oh, one more thing, Randy. I just wanted to clarify that I know I have told teams that courtroom artists cannot participate on the mock trial team. So we've clarified that this year. The courtroom artist may participate on the mock trial team. It's just round one or round two. They're either one or the other. So they're not
Right.
able to be an artist and then stop and then go do their role in mock trial. It's one or the other between one and two, rounds one and two. So I just wanted to clarify that because I don't think we did that. But thank you, Randy.
Thank you, Kim.
And I think now we have Nick Hajdukovic and Peter Stelter who are going to present the case.
Great. Thank you, Kim. Peter's going to pull up the PowerPoint here. While he does that, I'll just briefly introduce myself. My name's Nick Hajdukovic. I'm the chair of the Mock Trial Committee. I'm also a prosecutor in the Washington County Attorney's Office over in Stillwater, where I'm the head of the criminal division. I've been doing mock trial since I was in high school in various capacities. Starting in about 1996 or 97 is when I would have started. So, Peter, do you want to introduce yourself?
Yeah, my name is Peter Stelter. Unlike Nick, I am not yet employed. I'm a third year law student at Mitchell Hamlin School of Law. Um, but similar to Nick, I've been doing mock trial for a great number of years. I would have started in, 2011 and have maintained some amount of status in the program every year since.
Great. Well, thanks, Peter. Why don't we get started with the presentation? So this year's case is Harper Lightfoot versus Jesse Gates. And before I get into it any further, I'll just remind everyone, again, you can use the Q&A feature to pose any questions you might have, and we'll try to answer them. One thing I'll note, just with regard to the case name itself, obviously, Lightfoot is certainly a reference to the Gordon Lightfoot and the wreck of the Edmund Fitzgerald song. And I think the case overall this year is there has been, in the last few weeks, a ton of press about the wreck of the Edmund Fitzgerald and the whole tragedy of the situation. There's a documentary available. I believe it's Fox 9 that did it. So I would encourage everyone to take a look at those things. It's very interesting stuff. We tried with the case this year to go back to the 50-year anniversary of this Minnesota tragedy, but also to incorporate some more current issues we're running into with things like artificial intelligence. And one other thing to note just about the case name is that you'll see that the defendant is Jesse Gates. We all know that in real life, this would, of course, be an incorporated entity that would be sued. We did it this way essentially for the sake of simplicity. It's just mock. That's why we did it this way. We know that that's not super realistic, but it simplifies some of the legal issues that really don't advance the case at all. So we can move on to the next slide. Thanks, Peter. So I'll just first of all, start off with a brief overview of the case. It's a civil case this year brought by Harper Lightfoot against Jesse Gates, not a corporation. And Lightfoot alleges that Gates published some defamatory statements to the effect that Lightfoot stole a life ring from the wreck of the Edmund Fitzgerald. There is actually a recent article I read about some of those life rings that were found from the Edmund Fitzgerald. So Gates, on the other hand, alleges that the statements were true. So that's a crucial part of the defense here is that, and one of the fun things about a defamation case in general is that it allows the teams to argue about whether certain events actually happened or whether the statements are true, because that's a defense. And therefore, if there's a dispute about whether the statement is true, there's going to be a dispute about what actually happened. And then Gates also alleges that the statements were not made with reckless disregard or knowledge that they were probably untrue. And I'll talk a little bit about the significance of that when we get to the legal issues. We can go to the next slide and talk about the pleadings briefly. So, for those who don't know, in a civil case begins formally in court when a plaintiff files a document called a complaint. Essentially, what a complaint has to do is to allege enough facts that, if they're true, would be enough to prove whatever legal theories they're claiming. And here again, of course, the allegation is that there was defamation. The defendant then has to file an answer to the complaint. An answer is essentially the plaintiff going through paragraph by paragraph and saying what allegations of the plaintiff they admit to and which ones they deny being true. And anything they deny, then that puts, generally speaking, on the plaintiff to prove by a preponderance of the evidence. We'll talk a little bit about the burden of proof here in a little bit. There's a pretrial order in this case, which we do in most cases. Well, and the reason we do them is because we want to deal with some of the issues that would be raised in real life and just have formal decisions on them. We want to do that. For some reason, okay, there's our recording again. So a stipulation is a fact that is proven. In real life, a judge will instruct the jury when there's a stipulation that the jury should consider that fact, whatever the fact is, to be proven. So it's important because it really will help you in your opening and closings to know what is undisputed in the case and what you don't have to also necessarily waste your time with your witnesses trying to prove. And then finally, jury instructions. Those are really important. In real life, those are largely given at the end of the case after the testimony is in. And what the jury instructions do is they tell the jury, A, how to deliberate in the sense of, you need to elect a four-person. Here's the type of things you can consider. Here's the type of things you can't consider. But then they also go through the elements in the relevant law. And a judge in a case decides what the law is and instructs the jury on the law, and it is the jury's job to find the facts. And then they apply the facts to the law the judge gives them. That law is in the jury instructions. So those are extremely important because in your closing arguments, you're going to be referring to those jury instructions because that's what you do when you're arguing a case in real life. The judge has instructed you that, the plaintiff has to prove X, Y, and Z. You're not asserting that as the lawyer. The judge decided that. So those are super important. And we'll talk more about the jury instructions at the end. So we'll briefly just talk about the law of defamation. And some of this is in the jury instructions, including those elements or the things that have to be proven. So the first one is that the statement or communication must be defamatory. Now, it was brought to our attention after we released the case that we actually didn't include the definition of the term defamatory. And I would anticipate that will be the subject of a clarification in the not too distant future. So don't stress out about that. The term means basically what you think it would mean. The statement has to be false. the statement has to refer to the plaintiff and it has to be published, meaning it's communicated to someone other than the plaintiff. And one of the big things in a libel or slander case like this is that when the plaintiff is what's called a public figure, there's an elevated requirement in terms of the elements. So the way it works is this: if your plaintiff is not a public figure, and I'm simplifying this a little bit, but this is accurate. If the plaintiff's not a public figure, then the statement or communication only has to be essentially there has to be a negligence standard met that the defendant knew or should have known that the statement was false. But if the plaintiff is a public figure, um, it becomes much harder for the plaintiff. The plaintiff has to show that the defendant either knew that the statements were false or made the statements with reckless disregard as to whether they were true or false. That comes from a U.S. Supreme Court case called New York Times versus Sullivan. And that's really a requirement the Supreme Court has concluded is necessary based on the First Amendment and essentially ensuring the freedom of the press and the freedom of speech. That higher burden or that higher requirement has been imposed by the U.S. Supreme Court. So that is a part of this case. The other thing I would just note is that, and I think this may be addressed later again as well, the burden of proof for all of these is a preponderance of the evidence, sometimes referred to as the greater weight of the evidence. They are interchangeable. They mean the same thing. They mean it is more likely than not. 50.0000001% chance that it is true. Is any number greater than 50% essentially gets you to a preponderance standard. In some cases, we've included defenses where the defendant has some sort of burden. We did not do that in this case, again, because we're trying to have a certain number of discrete issues in the case to allow it to fit within the confines of what can be done realistically in a mock trial case. So all the burdens here are on the plaintiffs, but on the other hand, it is a relatively low burden. So um, it's true that it is the plaintiff's burden and not the defense's burden to show all of these things. But on the other hand, realistically, the defense is probably going to have to put on evidence because it's essentially who do you believe, the plaintiff or the defense? Which one's more likely? That's your standard. So although the plaintiff has the burden, it's not always as effective, I don't think, to really pound on the burden in closing argument as it is in a criminal case. It's something to discuss, but I don't think it's as powerful. So we can move on. So the next section of this presentation is going to be about the witnesses in the case and just kind of going through each one and giving an overview of each. I'll go through the plaintiff witnesses and then Peter will take over from there for the defense witnesses and then through the end of our presentation. And the witnesses can be called in any order, of course. We're just going through them, I believe, in the order that they appear in the case materials. So Harper Lightfoot is, of course, our plaintiff in this case. Harper owns a business called Icy Dives and used to be in a business partnership with Gates with Icy Dives. They had a maybe not super great breakup in their business, of course. And of course, because this is a mock trial case, there are money problems. Um, and, so that adds to sort of the issues in the case. The two companies, Gates's current rival company and Icy Dives, alternate weekends in doing dives in Lake Superior to the Edmund Fitzgerald. And Lightfoot, unlike Gates, offers in-person dives, which is kind of one of their key differences in how they run their businesses. Lightfoot also works with treasure hunters and collectors, which makes for some interesting, certainly, dynamics in the types of people who are in those industries. So that's the plaintiff themselves in a nutshell, and I think that it's obviously a very important witness for the plaintiff because if the plaintiff isn't credible, there's no way the plaintiff is winning their case. So the plaintiff's got to be believed, and it's there's going to be plenty of room for cross-examination on the plaintiff in terms of money issues and all sorts of things, and their dislike of Gates and all sorts of things that are going to provide plenty of grist for cross-examination. So Jackie Cousteau is the next witness. Jackie is a diver and shipwreck hunter, and of course, the Cousteau is a reference as well, although a different spelling than the French Cousteau. But this is kind of an interesting witness because Cousteau is in some ways an expert witness, but has also been friends with Lightfoot for about 20 years. Um, so there's definitely some bias there to be explored on Cross. Cousteau suggests that natural causes could have caused the life ring to come loose and then float to the surface and sure to be found by someone else, i.e., that Lightfoot was not the person who took the life ring. Um, so that's that witness. And then Billy Warrens is the final witness for the plaintiff, also an expert witness. So Warrens is an interesting witness and is modeled off in some ways maybe a real life person, but also very different from that person. Warrens is an expert on the ethical use of AI. Um, and Warrens talks at some length about how not using the correct prompts um, to generate AI content rather can cause problems. And then talks about the ethical requirement to verify the truth of AI generated statements before publishing them. That's going to be one of the big issues in the case. The pretrial order makes clear that the defense can't blame this chat CPT program, program for making the statements, because ultimately the statements are the statements of the defendant. But there's still one of the big questions I think that's out there on AI right now is how careful do you need to be? And what are the sort of ethical requirements for using AI to generate content that's going to be published online for anybody in the world to see? It's really important stuff to think about in terms of how careful do you need to be, and that balance between a business where you only have limited time, only so many hours in the day, and you need to generate this content to assist your business. How much time can you realistically put into it? What is negligent, and then more importantly to this case, what is reckless disregard for the truth. And then there's a little more on this witness too on the next slide. Essentially, Warrens opines that Gates is liable because they used AI prompts that were designed to produce more sensational headlines and drama rather than factual information and more neutral information. And also that Gates should have verified the truth of this AI generated content or even like took a look at it before having it posted on the internet, given the high rate of inaccuracy of AI. So that's going to be one of the big questions in the case is, again, how careful does a person need to be that when they're using AI to publish information on the internet, especially in a situation where, like here, you might say, well, this AI, the intent was never to trash people with this AI, with this company. It was really to produce content about dives to the Edmund Fitzgerald, and it just happened that it caught these statements and made them into what it did. So it creates some interesting issues, and that's what this witness is all about. With that, I'll turn it over to Peter.
Great. Thanks, Nick. So, starting off with the defense witnesses, you have the defendant in this case, Jesse Gates, similarly named after famed treasure explorer Josh Gates from the Discovery Channel. Like we discussed before, Jesse Gates was a former business partner of Lightfoot for several years, but now Jesse Gates operates the business Superior Depths. Again, notwithstanding problems of incorporation for the business, the way that the plaintiff and the defendant are operating their businesses is that they're going to alternate weekends, diving down to the Edmund Fitzgerald. So the plaintiff would take, the first weekend, defendant would go down thereafter. And they're the only two people as of right now to have diving permission to the wreck. Again, unlike the plaintiff, Jesse Gates is going to offer virtual reality dives to the wreck. So there's some sort of, they will be essentially on a boat on the lake, and they'll send down a remote submersible with a VR headset for the person to be able to watch as though they were actually in the water. Um, Gates discovered that the life ring was missing and cursed out and accused the Lightfoot of stealing it. Um, there is supposedly audio and visual recordings that happen on the boat itself. Um, that audio was summarized and placed into an AI generator, which then accused and created a summary that accused Lightfoot directly of stealing the life preserver ring. And Jesse Gates published this video to their own YouTube channel. The next witness we have is going to be a witness, Cook Gamby. They are a collector and broker of marine and maritime artifacts. They spend a lot of their time advertising and working with Jesse Gates. So similar to the way that Cousteau is a de facto friend of the plaintiff, we've also provided the defense side with their sort of by-character witness to have a personal relationship with the individual whose side of the case they're on. Cook Gamby, like we mentioned in talking about the plaintiff, Harper Lightfoot has an interest in deals with brokers and treasure hunters, and so Cook Gamby has interacted with the plaintiff to help them acquire some artifacts. The alleged site to which the life preserver ring was posted is a online auction website called CBay. And Cook Gamby monitors the plaintiff's account and sees what they are posting and what they're not. Cook Gamby's main claim is that Lightfoot wanted the artifacts from the Fitzgerald and sold it and wanted to sell these artifacts to private collectors and instead of museums. So a reverse Indiana Jones in a way. Cook Gamby is going to be one of the witnesses who probably their basis is to suggest that what was in the defamatory statement is actually true. Finally, we're going to have our defense expert witness, Alex Ignacy, who's a digital content creator and social media strategist. They teach courses on artificial intelligence use, and Jesse Gates was one of the students at one of these webinars or courses. Defense expert is going to suggest that Gates probably may not have known that the alleged defamatory statements that they were given were false, or that they were doing it with reckless disregard, that it's more likely that these are just passive prompts that were put in, and it doesn't necessarily likely amount to the heightened level that defamation arises to in this case. He is also particularly familiar with the AI program that's used, ChatGPT. We've had a great amount of fun with a lot of ocean-based puns in this case, as you can see. There's going to be a total of 10 exhibits that we've given to you to be able to utilize during the course of the trial. Again, as a reminder, each witness declares what specific exhibits they're familiar with at the end of their statement. So not every witness is going to be able to talk about all 10 of these exhibits. There's a select few that can be talked about by each witness, but you should be able to enter all 10 of these at least through one of the witnesses that are being called through the course of the trial. Some quick general notes on using exhibits in trial. Just as a reminder, exhibits can help to enhance witness testimony. It provides a nice, visual aid to what somebody's actually saying. So if you need, rather than describing a picture, if you have that actual picture, you may as well show that to the judge or the jury. Um, think about ways to use exhibits. What do they tell us? Are they objective? Do they fill in the gaps in the story that the witness's own affidavit might not? Um, Again, we've said it before, said it again. There's witness familiarity set forth in each of the witness statements. Be familiar with the stipulations that are relating to the exhibits. Um, know how to lay foundation for each exhibit that's offered, and those are laid out in the mock trial rules of competition. Um, Lack of foundation is a possible objection, but it's a potentially easy fix. You just need to re-ask more questions to talk about, what is it? How does that person know it? Exhibits can be objected to grounds other than simply foundation. So documents like videos could be hearsay, and they could be ruled inadmissible on other factors that aren't just foundational elements. There could be something prohibitive in the document itself. Be prepared for any argument for or against admissibility. Even if you think a document might not fall under a particular objection, just be prepared to talk about why it should be admitted or excluded in particular instances. Teams are going to have different approaches to how they're going to use the exhibits in trial. That is okay. Those are stylistic issues for the judges to determine, and it's not necessarily a rules violation if they are not using exhibits in the exact way that you've trained your team to. And just, as a reminder, exhibit handling and use are very important skills in mock trial. They are skills that are going to help, separate teams from one another. If you can demonstrate that you have a real mastery on how to use exhibits during the trial to help your narrative, that's going to help you overall. Note the rules on enlargement in Rule 4.11. Specifically, there's a lot of different specifications to how you can enlarge an exhibit. So refer to the language and the instructions found there if you'd like to expand for better visuals for the judge and the jury during the trial. The jury instructions. So we talked a little bit about this earlier. The jury instructions are going to be given by the judge to the jury at the close of the case. They won't actually, during the course of the mock trial, they won't actually be handed a full physical copy of jury instructions for tabulations because we're based on score. We're not based on the actual merit of the case. But it is important to kind of help guide the way that you should be approaching the problem. The jury instructions are going to lay out the elements of defamation that has to be proven, the burden of proof, and the way that certain pieces of evidence should be treated. There's also they're given guidelines on how to evaluate testimony. So the judges are going to decide, what testimony there is and how much weight to give it. The pretrial order, again, we talked a little bit about this earlier. There's already been previous rulings on a number of issues to kind of limit the types of things that teams are going to be able to actually bring and argue. So a judge has already de facto ruled that Lightfoot is a public figure. So you can't walk into a trial and make an argument that that the plaintiff is not a public figure for that heightened level of defamation. Pretrial order rules that the plaintiff must prove that Gates published the statements with the knowledge that the statements were false or with reckless disregard as to whether they were false. There's also opinions on the treatment of opinion testimony. See also the rules of evidence in the 700s. Other things that have been ruled is that it was, in fact, Jesse Gates and not ChatGPT that published the statements. So the defendant cannot walk in and say, I'm not liable because I didn't actually publish these statements. That's not an argument that we've decided to narrow that down as well. Gates can make the argument that the reliance on the AI tool and ChatGPT shows that he didn't make them with knowledge that they were false or with reckless disregard. So you can give that more weight to the actual AI experts and those provisions, but you can't walk in and just say he didn't do it outright. Think about what rules you might use to object as the defense and how you'll respond as the plaintiff, and whether or not those objections in relation to the pretrial order are worth it to the overall flow of your case. I just compiled some hints just as kind of a potpourri of a bunch of different ways in which effective teams move forward. Don't read from notes. That's found in Rule 4.21. You don't want people to go up with a full script in their hand and be looking at a piece of paper. We want the students to actually demonstrate a knowledge of the facts and the law, and that doesn't apply as much if a person is just standing and reading from a sheet of paper. Also, help the students to move around, use their hands, make natural movements, whether it's in person or on Zoom. Attorneys ensure that they look like they're listening to the witnesses' responses, taking notes, listening and preparing responses, so that they're actually responding to what is going on around them and aren't just walking in and giving kind of a predetermined set. Consider what each witness has to gain or lose in giving their testimony. We talked about things like bias that might be applicable towards a couple of the witnesses on different sides, or even what the plaintiff and the defendant both have to gain or lose in bringing this suit forward. Always give the judge a reason or an argument to trust your side, even if it's a really 50-50 situation. In both presenting evidence and arguing objections. The only way you can guarantee that you're going to lose an argument is to punt on it or just allow the others or agree with the other side. Always give something, any reason at all to verify your argument and what you're trying to do. When cross-examining fact witnesses, remember what exactly you want from those witnesses and to help maintain control of the examination. Witnesses, develop and show a personality. We don't just want reflections of people from the pieces of paper. Actually allow them to be their own person and develop a different character. No costuming or unfair extrapolation found in the rules there as well. And if there's a bunch of technical language, help break down the terms and describe stuff and things in ways that people can understand. Treat it like you're explaining something to your grandma, is what I always say. At the end of the trial, you can argue reasonable inferences from the evidence, and witnesses can bolster or challenge testimony of other witnesses. And that's what we have for the case presentation.
Great. Thank you, Peter. I haven't seen any questions come through the Q&A yet. If anyone has questions, please put them in. We can try to answer them.
This is Randy. I do have kind of a question. The defendant says that the facts are true, that Lightfoot took the ring. And I noticed that you had stated that there's no burden shifting. Sometimes you have a situation where an affirmative defense can shift the burden. And I'm just wanting to make sure that that we're all understanding that, in fact, the burden to show that Lightfoot has to prove I didn't do it. Is that correct?
So yeah, the burden is on the plaintiff to show that the statement is false. Um, in other words, Lightfoot has to show that no, I didn't take the ring by a preponderance of the evidence. So yes, it's kind of an odd thing because but like I said, the just the way burdens work in civil cases most of the time, yes, the plaintiff has the burden of proof, but the defense is still realistically going to need to present evidence because sometimes people get mixed up on terminology too. Because, and I know you're not Randy, but other people might be on. We might say the defense is that it is in fact a true statement. That doesn't necessarily mean an affirmative defense where they have the burden of proof. It's just a defense, meaning that's our counter argument to their, to their claim. That's how we're going to, that's how the defense is going to prevail. So it is a defense. It's just not an affirmative defense in which they have the burden of proof. The plaintiff has to prove that it is false.
Okay, well, again, I don't see any more questions, so I think you guys did a wonderful job in presenting the case and the rules. Just a reminder to anyone present, there is a coach webinar on Wednesday for any coach to attend. I highly recommend that you RSVP and attend that Wednesday afternoon session. And then we also have a timekeeper training in December. Again, I recommend our timekeepers attend that short session. Otherwise,
Right.
thank you all for attending. And Nick,
Thank you, everybody. I hope everybody has a great day and enjoys the case this year and has a great season.